have seen that there have been numerous motions to disqualify judges, up to 17 motions. While I do believe Mr. Blandino is well versed in the law, could represent himself adequately, and maybe even exemplary, I do have a problem with his use of motions to disqualify judges. It seems that every time a judge looked at the case, motions to disqualify were filed. State of Nevada versus Kim Dennis Baldino, 22 CR 041030. Counsel, sorry to make you wait. Every road I had an accident.
Morning, Your Honor. This is usually handled by Mike Dickerson.
Yes. State, you have the file?
I do not.
Okay. Did you talk to Mr. Dickerson?
I have not, Your Honor.
I mean, is he coming? Do you know if he's showing up?
I was told he was coming.
For the record, Mr. Blandino is present in custody.
Excuse me, Judge. It's Blandino.
Blandino, I'm sorry.
If you want to just call me Kim or Mr. D,
Well,
whatever.
I'll call you Mr. Blandino. I'll call it the proper way to call it. Any idea?
I don't, Your Honor. I can try and get a hold of him.
You don't have the file, State, right?
No.
You have another place to go to?
No, Your Honor.
Sorry, I know it's
No worries,
backed
no worries.
up. No, it's just,
No worries.
All right, sir, have a seat. We'll get back to you in a few minutes as soon as Mr. Dickerson gets here.
Your Honor, sorry to bother you. I've just been informed by the state that they have coverage for the Blandino
Okay.
matter.
You got that one?
I have it.
All right, let's recall that one. State of Nevada versus Kim Dennis Blandino, 22 CR 041030. Mr. Blandino is present in custody. This was on for two issues. One is he's in custody on a probation hold. Regardless of what I was doing, he was still going to be in custody on that, right? And I believe he's still in custody on that matter?
Yes, Your Honor.
All right. Now, also, the other issue is, we'd set it for Monday. I understand that you called and asked for continuation on this matter, and I granted that because of the matter that you had issues that you had to deal with.
Thank you, Your Honor.
Holiday, so I granted that. Now, we're here for the issue of bail setting and whether or not he's going to represent himself. Anything, there was an argument made last time regarding this. Mr. Dickerson asked for no bail, given the fact that he's on probation. He's currently held on a probation hold.
I just want to add, Your Honor, it's kind of bizarre because Mr. Dickerson's his argument is he's actually not on probation because he failed to sign, but he's arguing for a revocation. So it's this kind of bizarre thing.
Well,
I don't know how you want to treat that.
That's probation is going to have to deal with that.
Okay.
So I need to deal just with the bail here today. Mr. Dickerson's argument was that because he's got a probation hold, on probation, he's not entitled to bail. Read the statute again and again to confirm that he is entitled to some kind of bail on this. Do you want to add anything further, Mr. Chairman? Because at length some arguments.
No, Judge, I spoke with Mr. Dickerson.
Okay. Mr. Gersten, anything further?
Just, Your Honor, I'm sorry, Your Honor. May I
Please do so.
consult with my client? Thank you.
Mr. Gersten, do you need some time? I can pull some other cases if you want some time to talk to him. You trail it right now?
Yes.
All right.
Thank
Let
you
me know when
very
you're
much.
done so I can handle some other matters. Sir, have a seat. I'll get back to you in a few minutes. All right. Recalling State of Nevada versus Kim Dennis Blandino, 22 CR 041030. Mr. Blandino is present in custody. Mr. Gersten at this time is representing Mr. Blandino. Mr. Blandino, you requested some additional time to talk to your attorney. Do you speak to him regarding this matter?
Yes, we
Oh,
will.
okay.
Your Honor, my client would like me to stand next to him.
Okay. Perfectly fine.
Thank you.
As I indicated previously, this is two issues before this court. One is representation by Mr. Blandino representing himself, and two, setting some kind of bail in this matter. State, you have nothing further to add from the last argument that was made last week?
No, Your Honor.
Defense.
Let's see. Your Honor, on the Ferretta issue, I think Mr. Blandino has every right to represent himself in this courtroom. That's really what he wants to do. I'll be honest with you, I have zero client control, so letting him represent himself is going to move this thing a lot faster. I will be standby counsel. Mr. Christensen has approved that. So at this time, there's no reason why he cannot represent himself under Ferretta.
All right. On the bail issue, does Mr. Blandino wish to address the court regarding this? Without talking about the facts of
Yes, Your Honor.
the other case.
And
for
simply
this
put,
case.
Your Honor, as far as the bail issue is concerned, if what you're we're looking at, there's a question of the seriousness of the alleged issue is lack of insurance and lack of a driver's license. That's number one. Number two, he's already been determined, I'm sorry, registration, Your Honor, I apologize, registration, not insurance. With regard, he's already been determined to be indigent. I represent him in both his district court case and his direct appeal under the Office of Appointed Counsel. He has not missed a single, as far as I'm aware, matter. He, in fact, enjoys coming to the court and addressing the court. So I don't think there's going to be any issue with him not showing up to defend himself against these charges. Tremendous ties to the community, et cetera, et cetera, et cetera. And last, I did want to add this, Your Honor, because Mr. Dickerson was bringing this up at the last hearing. He is a caretaker for an elderly woman. Mr. Dickerson mentioned how they had sent out well checks and she was perfectly fine. P.S. She's in the hospital now because fell ill without Mr. Blandino's care. So he needs to get back to be able to take care of her to do that.
All right. Turn anything response. Anything further?
Can I speak to the bail matter?
Only to, when I say I'm asking only to speak to the bail matter, I don't want you to talk about the facts of the case at this time. So yes, speak to the bail
The facts of the
issue.
case relative to bail.
Just the facts that are relevant in determining any kind of bail, or don't talk about the facts with any of the that are important to the trial itself or the hearing.
Okay, right. Well, study of all have the two factors. We have flight risk, danger to the community. The fact is that, Lord, I don't have any failure to appear at all. Part of that judge is covering this case. So even if you say it's narcissistic for me to want to come here, and that's my motivation, fine, you can say that. But it gives me, from that point of view, every reason to appear so I can be on YouTube this now at this moment. So as to OR, I believe OR is totally appropriate. There's not violence. There's never been any violence in there. The way Mr. Dickerson, what he is that Mr. Blandino can't abide by any laws, any rules. This is patent nonsense. He's arguing like a 10-page guy out there. He mentioned the 1994 conviction. And one thing I needed to address relative to that is your concern that you presumed that there was a custody order was violated. No, 200.359, the pre-October 1993 version, that a person who conceals, detains, or moves a child from another person who claims the right to custody of his, no court order was needed, and I negotiated myself, representing myself, a plea bargain of credit for time served of 1 day misdemeanor, which is allowed within the statute at that time. God would not let me take that plea bargain. I see the wisdom of it now as to the experience that I got with the law, being able to speak and walk, talk, and chew bubble gum if the court gives permission to chew the bubble gum in the courtroom at the same time. And so the thing is that there was no court order violated. I would never have done it. In fact, and I testified to this, I went to an attorney before I took exclusive possession of my kids, and he said it's no crime if there's no court order if you take exclusive possession of your kids. But that was proven wrong, and so did not violate any court orders. When the court gives me an order, as long as it's understandable, I make every possibility to make sure it is understandable. I follow that order. And as a matter of fact, part of this probation conditions is for me to file no fugitive documents. Yes, okay.
Don't.
But I'm just saying.
Okay. You're okay with that? I just don't want you to get into the probation issue or
what I'm saying
any
is,
theories of defense you have in that.
Against my will and over my objections, you forced counsel on me. That's the terminology that and the other cases along that line. I have forced counsel, so I could have I had a motion under Riverside v. McLaughlin that day, as you recall, and I was in the high-risk transport thing, which we got resolved. The jail, this was some retaliation from 2 years ago that was still lingering on my record. I'm not high-risk transport. I don't know. They did say on the kiosk that got resolved. That only felony prior to the one I was for this one, and now as to the bail, one thing that seems to puzzle me in this respect is they made it sound like, well, I'm not going to get let loose on the other one, the probation violation, so bail isn't an issue. That's not true. If I can have,
I agree with you on that.
okay,
That you're under the statute.
under Valdez versus Jimenez.
No,
Well,
under the statute itself, it says that you're not entitled to bail unless by order of the court. So that's what we're here for. So
and I think
I don't believe that I'll put on the record, I don't believe a no bail is mandatory.
I think OR release under these circumstances is entirely appropriate. You have my word of honor, my vow before God that I appear, unless it's an act of God that stops me, earthquake, hurricane, dead, you know, I'll be here.
Anything further, Mr. Gersten? State for the record you submit again. All right. Court will note two things. We're focused on the bail at this point. I've got possession of documents of personal identification of another Category E felony. What it is that he's walking or driving around with a driver's license. So it's really that he's not trying to pretend to be something else or somebody else for doing that. And then I got count 2, resident failing to obtain Nevada registration, and count 3, driving without a valid license, which goes to count 1 because he's believing or may believe that he's got an international license. These are basically traffic matters. I would not hold somebody no bail on traffic matters. This could have gone through 90 days. This becomes not civil infractions, but civil collection. They no longer look to put people in custody. So for this court to look and say, you know, he's got charged with theft, he's on probation, these are traffic. We all get traffic matters. So I do not believe a no bail. I don't believe holding him no bail is appropriate in this matter. Focusing on his criminal history and what's going on so far, I do believe an OR release is appropriate under the conditions. I want him to check in once a week, physically check in on ISU. All right?
I'm sorry, what on
ISU, intensive supervision. You must come to the court. You must check in once a week, giving these charges being that truly they are just traffic violations. Even though one is charged as a felony, a Category E felony. Safety of the community, return to court, I think we get that with a check-in once a week. So I'm going to grant an OR release at this time with ISU checking in once a week. That being said, the other issue that we're focusing on is his Ferretta canvas, whether or not he has a right to represent himself. Mr. Dickerson provided to this court an order granting state's motion to revoke defendant's self-representation, which was filed up in district court, signed by, I believe, Judge Levin on this one. I've reviewed this matter. I have seen that there have been numerous motions to disqualify judges, up to 17 motions. It looks like there are just to harass and the courts. I do not believe, while I do believe Mr. Blandino is well versed in the law, could represent himself adequately and maybe even exemplary, I do have a problem with his use of motions to disqualify judges. It seems that every time a judge looked at the case, motions to disqualify were filed, including judges who hadn't even been assigned to the case. So, looking at his past history under representing himself, I feel that there is more of an attempt to harass the court proceedings, and the court process. And I do not believe at this time that it is in Mr. Baldino's or the court's best interest to have him represent himself. I do not believe that it is an attempt to represent himself with the best interest other than to harass the courts, the DAs, or the proceedings. So based on that, I'm denying his motion for representation of himself. I am going to order Mr. Gersten to continue representation on this matter. You have every right to file a motion to appeal this issue. You have every right to do so. That is the court's order. I'll set a prelim. You want a prelim and trial, or you want to go prelim, then set a trial later on? You want a prelim within 15 days?
Well, if we're getting an OR, Your Honor, I think that you want to.
He's got a right to, he's got to consult with your client before you make that decision.
Please.
I granted no on this one, so he's out on this one. So I can set on the felony because there are two different standards. He may or may not want to testify at the preliminary hearing. He has to waive the right. But he's got a right and the last right to testify at a trial. So I want to kind of bifurcate him because I don't want to exclude his right to, if he decides not to testify at the prelim, but he's got a right to testify at the trial, but they're going to overlap. So I want to separate those two out. So, what do you want to do on the category one, count one? Want 15 days or not? That's only for the felony. Gersten. With your client, with your attorney, yes, sir. Not with the court at this time. The court's made a ruling. I'm just looking for an issue regarding the setting of the trials. Have a seat. We'll get back to you in a few minutes. All right. State of Nevada versus Jim Dennis Blandino, 22 CR 041030. This is time set, or this is for us to set the preliminary hearing and/or trial.
Yes, Your Honor. We'd like to set both the preliminary hearing and the trial in the ordinary court.
All right. Mr. Blandino, you understand you have a right to have a prelim within 15 days. You're waiving your right to have a prelim within 15 days. You have a right to have a trial within 60 days. You're waiving your right to have the trial within 60 days. You're not waiving your right to the trial or the prelim. You're merely extending it out. You understand?
I understand that, Judge.
And you agree with that?
If I were representing myself, I wouldn't waive. But
I understand that.
Counsel on me, I have to abide by he's my guardian.
All right. And you agree with the continuation at this time, right? Extending it out, correct?
Well, I object to you denying me counsel.
You have every right to do so. You have every right to file an appeal on this matter. The court has set forth the reasons why after reviewing the motion.
I know I'm not filing an extraordinary writ, Judge, because the appeal doesn't. I don't need
You have every right to do so. I'm just focusing right now, just setting the trial date and prelim date.
I understand that.
And I'm not.
But my position has to be, if I were representing myself, I would not waive that 15 days, but since you're forcing counsel on me, I see no other option. You're giving me a Hobson's choice, Judge.
All right.
Set it in 14 days, Judge.
All right. State is set prelim in 14 days on this matter. So count one. That
I
date will
object
be.
to that.
October 12th at 9:30.
And set a trial
I'll
within.
accept it in the ordinary course. I'll accept it in the
All right.
ordinary course.
I'm going to give you time to go over this. I will defer to the defendant as to although the state has a right to request a prelim, I don't believe this is a situation where we need to invoke the state's right to hearing within a certain time. So, set prelim ordinary course as to count one. That date will be?
November 17th at 9:30.
And let's go sometime after that for the trial on counts 2 and 3. That date will be?
December 1st at 9:30.
Thank you, Your Honor.
I relied upon the order granting state's motion to revoke defendant's self-representation that was signed back and filed back on December 27th. Part of the record, court exhibit. It will not be able to be viewed by anybody else. I believe it's a public record anyways. But the court did rely upon that. So I am making it part of the record. So it is in the record. When you file your appeal, this will also be there, that you'll be able to rely upon that issue, the court review. All right?
Thank you, Your Honor.
All right. See you back here on that day.
Wait, no,